Hello, I'm Alvy C, and thank you for watching this video. To understand my explanation of this process, I have provided a complete chart of subsequent purchase electronic copy by James McGuire as a presentation, and will show you the steps in this process in order to complete the chart. By then, you should have a better understanding. If not, go to www.scrib.com/alvyc or www.ourlemon.com. The articles and charts by James McGuire are on both sites. To help understand this, let's start with the very beginning. Maybe it will turn the lights on. You have the idea that two parties are involved at the beginning, the borrower and the lender. But one should remember, someone had to sell something before you could buy it. So in the beginning, the future borrower found someone selling real property. The future borrower then locates a financial institution that will provide a loan for real property, along with certain conditions. The seller or grantor of the real property conveys title to real property to the buyer or grantee who is negotiating a loan. The homeowner is the grantee in the deed. Being distracted by securitization? There may be activities taking place in the background where a lender makes contract arrangements to get access to funds to pay the seller of the real property. This is not relevant in most cases. The point is, the lender provided the seller with monies. Is it really important to know where it came from? At the closing, the borrower signed a paper promissory note to the lender. The borrower is the obligor. The lender is the obligee. The lender holds the paper promissory note. The lender is the holder in due course. The borrower signs a deed of trust that is attached to the note as a lien that could affect real property. A security instrument as noted in the paper promissory note and signed by the borrower. Since there is a lien that could affect real property, one must look at both lien laws and property laws. When the borrower signed the security instrument, and according to local laws of jurisdiction, the security instrument held a temporary perfection status. This temporary perfection is for a limited time. Under the terms of the security instrument, the borrower is the mortgagor. The security instrument was required to reflect MERS as nominee for lender and lender's successors and assigns. MERS as mortgagee could be in dispute. Due to contract agreements with others such as the title company, Fannie Mae, Freddie Mac, etc., the lender is required to record the security instrument in public records. So the lender files of record the security instrument in public records to continue the perfection status of the security instrument. This filing of records must be executed before the expiration of the temporary perfection. Otherwise, it loses perfection status and the security instrument becomes a nullity. The lender then scans the note into an electronic digitized file, along with other loan documents for electronic use. The lender then uses the electronic image of the note under the pretense that it is within the guidelines of e-sign, UETA, and UCC Article 9 and declares it an authoritative copy. The promissory note is paper, tangible and personal property. After scanning, the paper note is allegedly vaulted by a custodian, and in conjunction with the authoritative copy, the lender is declared the owner of documents within custody of the custodian and who has control over the custodian. As the note was vaulted or destroyed, the authoritative copy is the instrument that is used for purchase by subsequent purchasers. The security instrument was required to reflect MERS as nominee for lender and lender's successors and assigns, the subsequent purchasers. The security instrument, the lien, when signed in conjunction with the note, allowed the security instrument to attach to the note with only temporary perfection. The temporary perfection is then permanently perfected by filing in public records. The security instrument itself does not affect title to real property, but directions contained within the security instrument direct how the title to real property can be affected under proper circumstances. Determining the legality concerning MERS being a nominee is better left up to the courts. The scanned copy of the note, the authoritative copy, is then electronically combined with a digitized copy of the security instrument and any closing papers to become the security collateral for the transferable record, the payment intangible. The security collateral was to represent the right to collect payments from the note and monies collected from the sale of property if a foreclosure sale was executed. Basically, at this point, MERS holds the security instrument and the lender holds the note. The lender will now use an electronic copy under the pretense of a paper note and deed of trust and sells that electronic copy to subsequent purchasers. The authoritative copy that represents a copy of the homeowner's note, the negotiable instrument, lacks supporting laws to exist. With the authoritative copy lacking supporting laws, the transferable record is secured by nullity. The transferable record did not achieve holder in due course of the homeowner's note. The transferable record is subsequently sold to a subsequent purchaser. Fannie Mae, Freddie Mac, as well as the securitizers are all subsequent purchasers of the transferable record and do not achieve status as holder in due course of the homeowner's note. With each electronic transfer of the transferable record to a subsequent purchaser, the underlying collateral, the security instrument, contains requirements that must be complied with. With each movement of the note, the security instrument must reflect a proper chain of title to reflect a new owner of the note. Without a lawful assignment of mortgage to a subsequent purchaser recorded in public records, the security instrument becomes a nullity. In Texas, Chapter 192, Section 007 states it must be recorded. Additionally, if the note resides in a vault endorsed in blank by the lender, there is a concern as to how MERS can be a nominee for subsequent purchasers of the note when in fact there has been no purchase of the note as reflected by the lack of chain of endorsements. As Fannie Mae, Freddie Mac, and the others have committed fraud in regards to the note, holder in due course will never be able to be achieved. The investor purchases a beneficial interest in trust certificates. The certificates and payment intangibles are personal property. The local laws of jurisdiction that affect real property do not apply. The payment intangibles carry the underlying collateral, the mortgage. The underlying collateral is the note and security instrument. The laws that govern the payment intangibles are different from the laws that govern real property. If the underlying collateral has not continuously complied with the requirements within those instruments to comply with laws that govern, the underlying collateral is defective, rendering a fatal flaw within the payment intangible. The investor, the subsequent purchaser, receives monies from the trust certificates they purchased. Those monies, in turn, might be used as a source of funding for other mortgage loans. The investors actually bought certificates that were not lawfully created. The taxpayers bailed out Fannie Mae and Freddie Mac's fraudulent purchases. The AIGs of the world issued insurance on what was not legal. So why are all the screams of the risks were not disclosed when in fact the certificates could not lawfully exist? As James says, so long as the money flowed, nobody cared. So there you have my explanation of Subsequent Purchaser Electronic Authoritative Copy by James McGuire. There is more to this, and you can read it on our sites mentioned at the beginning or in the credits at the end. Thank you for watching this video. If you understood or are interested in more information like this, visit our websites. Thank you.